At the end of the presentation, and the presenters will be happy to answer your questions.
Okay, they're good. Okay.
And second, we thank you for your patience. Again, Mediation. Please join me in welcoming them.
Hello, everyone. Vicky, can you move it? Thank you. So we have bios at the beginning of our presentation, and so I'm not going to spend too much time on this one because I think you can all read it, and we're a little bit late, so we want to dive into some of the materials. But all of us have done quite a lot of work in elevating children's voices in family law proceedings in different ways. And so we want to spend a little bit of time talking with you about that today. All right.
Similarly, the next slide, a little bit of background about myself, but you can read that. You've also got all of this in the PDF that participants receive. So I'll move it forward then. Thank you.
Same is true for me, so we can just skip over this.
Okay, great. Okay, so we're going to just start with a little short primer on children's rights. And this quote from the Supreme Court talks a little bit about where we've come from in just a couple of sentences in terms of children's rights. So, 100 years ago, children were considered property. And that was one end of the spectrum pendulum. And then as the years progressed, we've swung all the way the other way to children needing to be protected and overprotected. And now currently we've really evolved into understanding that children have rights, that they're a vulnerable group that needs protection, but that they also need to have their voices elevated. So we're in a state right now where we don't want to shelter their voice, but elevate it in a way that honors their rights, but also keeps them protected. So just some history. The United Nations Conventions on the Rights of the Child was one of the first documents to outline the importance of children's rights. And what it talked about is that children's voices should not be dismissed out of hand based on their age, but they should always be taken seriously. And children become more and more able to share their voices in an articulate way as they get older, of course, and as they develop. So Article 12 also talks about children being given information, and this is really important for family law proceedings, but they should be given information so they can share their voice and so that they know what's going on in their lives and in their family situation. In Canada, children have the same rights as all other humans under the Charter of Rights and Freedoms. That's an important consideration as well. And then finally, in the new Divorce Act, children's rights have been made explicit. And we must consider children's voices when making parenting decisions or family decisions that impact them. Their voices should be heard and respected and brought into the situation. Of course, the weight of that will be dependent on a lot of different factors, including their age and maturity. And then finally, we come to the Supreme Court, which talks about children as full rights bearers. Next slide. So great, thank you. So it's not just about children's rights or an ethical or moral responsibility to ensure that children's voices are heard, but the research also tells us that this is a really good idea for their well-being or for the well-being of families. So we know from research across the lifespan in all different kinds of sectors that people do better when they have choices, when they have voices, and when they can participate in decisions that are being made about them or for them. This happens in long-term care facilities when you involve older adults in programming for their day-to-day activities. And I think any teacher will tell you that if you give kids a choice in a classroom, you're going to reduce power struggles and get a lot more participation from kids in the classroom setting. So voice and choice is really important in all sectors across the lifespan. So it's not just about moral and ethical responsibility. It's also about the day-to-day benefits of well-being. And then there's been a few studies, one that done by the Office of the Children's Lawyer with Rachel Birnbaum. She looked at Voice of the Child reports And this was one way that they brought in children's voices in family law proceedings, not child protection, but in divorce and separation proceedings. And what they found is that it was very, very helpful for a lot of different reasons. Most professionals that they talked to in the study found that expressed that children's views and preferences were helpful for coming to resolution. All the children, every single one of them that were interviewed as part of the study, so that was 86 in this particular study, said that they appreciated the opportunity to share their voice, even if the decision wasn't in line with what they had shared. So, it's a really important approach, and it's a really important right for us to consider, not just in family law proceedings involving separation and divorce, but of course in child protection mediation, where the stakes are very high and the impacts to kids are, can be quite dramatic. So while the children have rights, we as adults also have responsibilities. There's a slide a little bit later on that is a brief that's written by Justice Donna Martinson and Justice Rose Raven, who have talked quite a lot about this and written about it in terms of what our responsibilities are in the justice system to make sure that children's voices are heard. So they talk about things like try to move things along really quickly, avoiding delays, making sure that the relevant facts or clinical data are included so that we can really understand the children's voices. So this would be things like understanding neurodiversity in children, understanding their development, and understanding their voices in the context of some of those developmental issues. And it's a similar situation in court too. People want all kinds of outcomes, and they express their views and preferences. If you think about a criminal court proceeding, you have people who will want an acquittal, or they want a guilty verdict, or they might want a certain amount of money for damages. And so people have the right to express their views, just as children would. It doesn't mean that the outcome of the legal situation is going to match up what they want. And that's the same with children as well. Expressing their views doesn't mean it's necessarily going to guarantee an outcome, but it is really critical to raise those types of issues. And I think anyone that works with kids in the context of family breakdown, you'll have kids say, I wish my parents could get back together, or I want to live with one particular parent. And it's possible that the facts of the case do not allow for that to happen. But that view and preference is really important so we can figure out a way to meet the kids' best interests and to honor how they want their lives to look as best we can. So the who and the how, of course, there's a real need for qualified professionals. There is training. Various jurisdictions offer training. We offer training. So it is really important that people have a really good understanding of foundational skills for interviewing children in this particular context. And it doesn't have to be discipline specific. All people involved in the legal system working with children and families, would benefit from having a really good understanding about children's rights, their voices, and how to implement those in the particular area they're working. So there's many things to consider, and Justice Martinson and colleagues talk a little bit about the important things to consider when raising children's voices. But one thing which is really relevant to today's conversation is that children have legal representation when their best interests are being assessed. And so we're going to talk a little bit more about OCL and CP mediation a little bit later, but this is a really important implementation issue that's been talked a lot about in the different literature that talks about children's voices in the context of family law disputes and child protection disputes. Okay, so I'll turn it to you, Vicky.
So the Ontario Association for Family Mediation is the organization that accredits family mediators, and also is the organization that oversees the child protection mediation. Certainly, I'm gonna catch myself. I always say the we term because I was on the board for many years, but I am the program manager there for CP Med, so I guess I can still say we. We have always considered the voice of the child as something very important and critical in terms of hearing what their wishes are. And so with that, we created standards of practice that these were created some time ago and are probably due for an update, but they're what's currently in place. So with respect to the vulnerability of children, mediation needs to be child-centered, and mediation must provide education and awareness and understanding of the needs and best interests of the child experiencing the conflict of others. And it's our role as mediators to educate the parents on the importance of the voice of the child in family conflict and consider whether and how they could have their voices heard in a safe and supportive way. Certainly later on in the presentation, we're going to talk about the different modalities in terms of hearing children's voices. But the overarching principle there is that their voices do need to be heard. However, when children's voices are heard, we are also clear at OAFM that their participation has to be voluntary, and that no child should ever be pressured into talking with a mediator or a professional, recognizing that not all children will wish to take up the opportunity to have a voice. Mediators should utilize the least intrusive method of bringing in the child's voice, considering their age, their maturity, and other relevant circumstances.
So this is
Yeah, go ahead, Dan.
this is the brief that Kim was referring to in terms of Honorable Donna Martinson and the Honorable Judge Rose Raven. There's also a number of fabulous resources, both briefs and other webinars, other materials on that website that's listed there that references this particular important brief. So when folks get a chance to take a look at family violence, family law, and then the French version .ca, you'll see a number of resources that have been put together nationally from various sites across the country.
So back to the standards of practice, mediators who are doing both family and child protection mediation have a wide range of options to bring the voice of the child to the table, and it can either be done directly or indirectly. And it's important to reinforce that if there is a lawyer or a clinician through the Office of the Children's Lawyer, that mediator should always attempt to speak with that person first. And certainly in child protection mediation, the process is different than it is for family mediation, such that at the same time a referral goes to the child protection mediator, and this is also true for family group decision making, a referral also automatically goes to the Office of the Children's Lawyer, and they then determine whether or not a lawyer will be appointed for the alternative dispute resolution process. And so if a lawyer is appointed for that purpose, then the mediator should be meeting with the lawyer first. And then if you're going to be involving the child directly, then you would do that in conjunction with the lawyer from the Office of the Children's Lawyer. So some other options, what are some other options to bring the child's voice to the table? Or Kim and Dan, do you want me to review those now, or are we going to talk about those a bit later?
No, go ahead. Thank you.
Okay. I'll do an overview, and then certainly Kim and Dan can add as you see fit. So a direct way of bringing the child's voice to the table is meeting with the child, and called child inclusive mediation. And so certainly when it comes to that, as I said, if there is a lawyer that has been appointed through the Office of the Children's Lawyer, bringing the child into that process, I would meet with the Office of the Children's Lawyer first. If the child wishes to be directly involved, then I would meet with their lawyer and them, and they would participate. in that capacity in terms of voicing their views and preferences to the mediator. Very rarely, unless it's an older child, would they be directly sitting at the table on the day of the joint session. If it's an older child, and certainly what we talked about earlier today in terms of the Ready, Set, Go program, they would absolutely be at the table. So I need to clarify those comments. There is something called a Voice of the Child report. And the Voice of the Child report is done by somebody completely independent. And similarities between the Voice of the Child and child inclusive mediation is that the child needs to consent to participate. The parties would need to consent for that process to occur in either circumstance. And only those points that the child is comfortable with the practitioner, whether it's a Voice of the Child practitioner, whether it's a child inclusive mediator, only those points that the child is receptive to having shared get shared. If they're not comfortable with anything being shared, then nothing gets shared. So there's child inclusive mediation, there's the Voice of the Child report, there's through their counsel from the Office of the Children's Lawyer if one has been appointed. It could be through the society worker may be able to bring, because they are required to interview the children, so they may bring their voices to the table. It could be by way of a letter or some kind of a document that a therapist with the consent of the child has offered to bring into the process as well. Have I missed any, Kim and Dan?
You talked about the letter. The other thing that some younger children will sometimes do is a drawing, or something that kind of represents what's important to them, and support around making sure that those types of materials are brought into consideration, and how to facilitate that is a big piece of some of the different training initiatives that are out there that we'll get to in a minute.
Great. Thank you. So our standards of practice at OAFM are very clear in saying that if mediators are going to meet with children directly, then they should have the competency and the experience and should follow best practices for working with children. And we would strongly support people taking training specific to child inclusive mediation. And you have two fabulous trainers on the panel here today, Dan and Kim. And so just to be clear, if you're going to be doing that, make sure that you've been trained and have the competency to do so. Mediators should encourage parents to share the parenting plan with the children, emphasizing that their voice was heard and considered.
So let's sort of talk a little bit about some of the historical aspects, and sort of so folks may have received training in family mediation, in terms of an interest-based approach to bringing forward views, interests, needs, etc. The children are not included in this process. They're not met with in terms of those aspects. So one of the things that really has been brought forward through some of the other changes in different legislation is thinking about and shifting consideration to make sure that things are more sort of child-centered, child-focused, whether it be mediation, child protection mediation, those types of activities. In terms of whether it's the children's lawyer that's helping to bring forward children's information, a child protection service worker, others that may be involved with the child in terms of helping to shift and include and enhance sort of a child-centered understanding to the mediation process going forward. Our next slide will sort of talk a little bit about some of the things to bear in mind, that mediators, you'll hear us talk a lot about training, and there are folks out there that do training. One of our last couple of slides and the material that you received talked about sort of different training options and versions. The key here is, do people have a good understanding of child development and children's needs? Do they understand some of those aspects? And you'll see us talking, about separation and divorce, because we know that a number of child protection mediation referrals also overlap with a number of the parenting dispute situations. And those can be highly complex and challenging. They can carry on and be, have been parties at battle for a very long period of time. And so the skill set in understanding child development, understanding some of the nuances of those particular aspects are critical to the child-focused mediation process. In terms of advocating for children, again, children are not brought into this process, they're not met with, but what you're hoping to do is ensure that the individuals that are involved in the mediation are thinking about, have an understanding of the children's views and points of view. But our next slide will highlight some of the hiccups that can arise when you're not actually meeting with children. So, some of the disadvantages of a child-focused mediation that doesn't bring the child's voice very clearly into the process is that parents may not have a good understanding of some of the things that are important to the children. They may be making some assumptions about what the children see as important. They may also clearly be at odds, and we see that in these long-running high conflict situations. They may not always be tuned in, so parents that are focused on some of the other issues that they're encountering in terms of financial, personal struggles, perhaps housing and other challenges, are less able to also pay attention to what some of the needs and concerns of the children are. And the other thing that we know can arise is that sometimes children will say what they know their parents want to hear, but that's not necessarily what they're looking for in terms of ideal solutions to their situations. They're just basically trying to get by in a very difficult situation. And so there can be some disadvantages if the children's voices are not included. And so, we'll jump further into the next section. In terms of, Vicky talked about child inclusive mediation. The big piece of the training in this particular type of skill-based effort around mediation and supporting children's voices in the mediation process is to understand and ensure that you've got a trauma-informed approach, you've got a developmental lens that takes into consideration neurodiversity issues, that you've got an element of understanding some of the challenges that can arise in child protection scenarios in terms of power differential, some of the other difficulties that may need to be balanced and supported, and either through the Office of the Children's Lawyer participating and supporting the children's participation, or through perhaps a Voice of the Child report or child inclusive mediation initiative to support the child protection mediation activities. So this is a closed process. We want to ensure that the children's views are completed, brought into it, that there's some clear understanding of confidentiality. There's also a clear understanding, and a big piece of the training and the steps that you'll learn, if that's something that you pursue down the road, is to understand some of the different stages and steps and practical aspects to ensure that not only do you have the consent of the adult individuals involved, but also the children, that you have a clear process for understanding what is important to the children, and also a very clear understanding of what they're comfortable having shared and what they don't want shared, and that is paramount and kept at the forefront. And you're very clear as part of the training also in terms of duty to report scenarios, safety concerns that may arise, and other situations that can need to be taken into consideration to ensure that we do no harm in the efforts to support children, to ensure that their voices are included in decisions about them.
Okay, so a little bit about the research. So there is some research on child inclusive mediation as well. And this is the work of Jennifer McIntosh out of Australia. And so they've done a number of studies where they compare people who did child inclusive mediation versus people who, the outcomes of child focused mediation versus the outcomes of family mediation as usual. And what they found is some pretty good results. It's, preliminary, and it would be great to have other research groups replicate the studies for sure. But what they found is that parents reported greater satisfaction with living arrangements 1 year after the child inclusive mediation was completed. And this is compared to child focused mediation and mediation as usual. They said the majority of them said that the children, or hearing their children's voices, was the greatest assistance in terms of the resolution of the dispute. And there were some similar findings in Rachel Birnbaum's study with the OCL Voice of the Child report set we had talked about earlier in the presentation. Child inclusive mediation had less motions, less hearings, and fewer orders in the year following resolution compared to the other forms of mediation. So people tend to stay out of court. The outcomes are more durable than they are in the other types. And so what this tells us is that it is really, so not only is it to the children's rights, but there are really important reasons in terms of durability and law and the durability of the outcomes of the mediations. Interestingly, families that benefited the most were some of the families that had the most or the poorest co-parenting alliance between the two parents. And what they found was that for some of those families, it actually helped to settle out the conflict a little bit. People were able to moderate their behavior and their engagement with each other as co-parents when there was child inclusive mediation, when they heard from their children directly.
So let's talk a bit about the child protection mediation process. As the whole PD day today is about, in terms of it's one of the ADR processes for addressing situations where a children's aid or a child protection organization and the parents perhaps are in dispute over how best to care for children, respond to their needs. As Vicky talked about, it involves not only a referral to the mediator, but also a referral to the Office of the Children's Lawyer for support for the individuals, the children involved, in terms of advocating for them. And one of the things that I'll let Vicky jump in on this in a second to sort of highlight is that sometimes the initial response will be that there isn't going to be somebody assigned. And I'll turn it over to you, Vicky. What do you do in that situation?
Absolutely. It doesn't happen often, but it has happened. In the earlier years, the Office of the Children's Lawyer used to sway away from the high conflict separations. They are now not doing that, luckily, in child protection mediation, because that is the bulk of what we deal with in child protection mediation. However, in the event that an OCL is declined, and if we as a mediator feel strongly that it would be very helpful to have their involvement, we can contact them directly and let them know our rationale for wanting a lawyer appointed. And I can say I've never experienced a rejection after that specific request has been made. And I know other mediators would have the same messaging. So sometimes they don't have enough information that they base that decision on, or whatever the case may be. But if we as a mediator contact them to say, would you please reconsider your decision? I've never experienced pushback from it. So,
and I think what Vicky is highlighting for us is the fact that when you reach out, you put the energy into connecting with them and highlighting how important this particular step is, and how it will facilitate shifting things for this particular family. Most likely you're going to be supported. You're going to see that it will be assigned. And unfortunately, some of the initial hiccups more arose from forms inadequately filled out, not sufficient information to really draw attention to the level of high conflict, to draw attention to the neurodiversity of these particular children and some of the issues at hand, and why someone else needs to help facilitate, bring forward perhaps an individual who's used to working with neurodiverse children gets brought in to ensure, the clinical aspects are also taken into consideration. The other piece, and I know some of you are in the audience, can't see you at the moment, but maybe when we break for questions, we'll sort of see a few familiar faces there. But some from the child protection field who are also really important to this process. Could be the children's service worker who has spent time with the children, who understands some of the things that are in place. It could be the family service worker or a key supervisor that's been working with this family. Individuals who work really hard at balancing the power differential, at ensuring that they listen to the adults as well as the children's important points of view that they want to bring forward, and are able to ensure that that information is also made available within the child protection mediation initiative, and so that can assist from those points of view. Sometimes, as Vicky said, arrangements may be made for a voice of the child report to be done to bring forward information to assist in the child protection mediation process if the mediator does not feel that they're sufficiently child inclusively trained to facilitate that. Or it could be that the mediator does a co-mediation with someone who has received the additional training in child inclusive mediation, and brings in that piece, and as a team, they facilitate those particular processes. I want to sort of draw your attention to the very last point, which talks about, I think I mentioned earlier, children's drawings or letters or information that they may say that, and then it's brought into the process. We have to be mindful that sometimes some of these other people that are working with the children only have a narrow view. And so we have to sort of recognize that they may not have the full family story, full information about all of the challenges that these parents have experienced. And so it'll be one piece of information that's brought forward, but there are other elements that the mediator is going to ensure also is taken into consideration by those that are helping to problem solve for this particular family. Thank you.
Just want to reinforce one thing. When it comes to child protection mediation, it is, I think it's an understanding that the child's voice would be brought to the table more often than not by the Office of the Children's Lawyer.
Sorry, Vicky, you froze.
And it's still frozen.
Yes.
Yeah.
No.
Well, I can jump in. I think this harkens back to what she was talking a little bit about earlier, is that if there's a decline in terms of seeing or having the OCL involved, a reach out to them about being included would be really important, and not and usually met with very positively in terms of the Office of the Children Lawyer then participating. And earlier we talked about the importance, and this is in various writings on this topic, of the importance of having children having legal representation in court proceedings. And that's a really important children's rights issue right now. That's very top of mind for a lot of people that are presenting and talking about this issue. And so in child protection mediation in particular, the OCL is pretty critical.
Kim, can
we
you
lost-
bring up the slides? Because I think we lost them when we lost Vicky.
We did. Let me just
Thanks.
try to do that. Okay.
So in case we didn't say it earlier, we should have said it. If folks have questions, you can sort of put it in the chat and one of us will monitor the chat and bring it into the discussion. We're almost through the slides. We want to sort of get to the last couple that really focus on the importance of the intake process. So Vicky was going to do this for us, but so intake with the CAS. So you're they're making a referral for child protection mediation. The OCL has been notified, responsibility, but again, depending on people's busyness and what information gets put in place, there may be a few hiccups, and so there may be no OCL involved at that point. And so your job as a child protection mediator would be to reach out, really strongly advocate for why it would be important for there to be one on this particular situation. The other thing, we haven't talked yet about the importance of understanding some of the cultural identities, the cultural humility that's required for doing this work. And so you may require an individual who is a First Nations trained child protection mediator for certain referrals, and in terms of or Inuit or Métis background, in terms of ensuring that the individual is comfortable to the parents and the community that they come from to help facilitate the mediation process going forward. So the next slide. So in discussing, the child's views and the OCL perspective, so you as the child protection mediator, you're going to talk to the OCL once they're assigned. At the beginning of your process, you're going to get information from them in terms of what they've heard from the child's viewpoints and how best to sort of facilitate bringing that forward into the mediation process. So some I know with older children and individuals, they will want to be present for at least part of the process, perhaps to come in and share information. I had one where it was very clear the adolescent wanted to come in and talk about what high school was important to them. And that was really the only thing in the plan that was needing to be addressed that they had a firm perspective on, and they were flexible around all the other things that were being designed as part of the solution to this family situation. But they did want to come in and say why they wanted to go to this particular high school. And that was a very important piece to that adolescent. And the parents heard it more clearly in that context. And that became part of the solution that was put in place.
Okay, so talking with children can bring out a lot of fears in people, especially when it comes to child protection issues or family law issues. So, especially when there are important clinical issues or concerns about violence or very young children. And so one way to think about this is that, children have the right to be heard. It's really up to us adults to facilitate that and to do it in a way that is going to meet their needs and keep them safe. And that's why we've been talking a little bit about the importance of training. To Dan's point, they might not have a strong opinion one way or the other about living with one parent versus another parent versus in a kin placement, but they are very focused on high school. And that is something that they really want to share about. Or there's extracurricular that they're really passionate about is where they found their stability and their friendships, and they want to make sure that is maintained. And while it might seem, not as big a deal in terms of their living arrangements, it actually could impact where they actually do live. If there's a consideration for them moving out of community when an extracurricular, for example, has been something that's really central to their identity and to their stability. So many things that the children share that are maybe not what we expected as adults are really important. And so really important to them and warrant some consideration. And the other piece is that we talk about wanting to keep children out of the middle of conflict and shielding them from all of these dynamics. But the truth is, and we know from the research, that the kids are already in the conflict. They know what's going on. They're living it every single day. Whether it's just being in limbo and not knowing where they're going to end up. And so giving them the information that they want and that they need in order to share their voice is really important. Keeping in mind that there are going to be some kids that don't want to share, and that's their right too. It's not about necessarily ensuring that they say something, but more that they are given the opportunity to participate or to decline participation in these types of situations.
May I add something to what I've been listening as a child protection worker working in the field of child welfare for the past 21 years? Can you hear me?
Yes, please go
Okay,
ahead.
great. Hi, I'm Uma. In very interesting conversations going on here. I just wanted to add in regards to the children's view and advocacy. And I wanted to let you know, in the child welfare system where I work, we have been doing a lot of signs of safety, where we are also doing, for children who are a bit older, also doing youth-led conferences where they are able to voice their opinion, talk about some of the things that are really important to him, important to them. It has been very successful because it allows them to be able to express their point of view, where they want to be, and the community and what's important to them, and sort of speak. These conferences can be held in different situations in terms of it doesn't have to be just with the parents, so that the parents don't feel like they're choosing one over the other. These are held in private with the youth who they feel comfortable with a worker or with someone else that they want to bring to the table, perhaps maybe a long-term relationship that they had and someone who they trust, and like foster parent or a program worker that they've connected with to some degree that they feel comfortable with and what have you. So they get to choose who they want to invite, or don't invite anyone, just want to talk to their worker, and decide how this conference is going to lead and what their wishes are and what they hope to accomplish in the process. So mainly we talk about what's working well, what are the worries, what you hope for, what is your best wishes for the future, sort of type of things, and then kind of categorize it into 3 different categories there. And usually they're very interactive and very visual too. So we would put them up on a board and a screen, and they get to decide, in terms of, so we're talking about the school piece, as you were mentioning, how a high school is so important to one particular youth. It may not be the same for the other youth. The other youth may say, well, I don't really care about it. I can go to any school. It doesn't matter. But for one youth, it's so important that that's part of their identity for different reasons. Maybe the girlfriend's there, or maybe they have a good LGBTQ, or maybe they just really like the principal there. It could be anything, or they like the academic program that they have to offer, or the means of supports that they have in place there. So it could be anything, or all of the above, who knows, right? And it's really important to keep that in mind, to kind of investigate, for the lack of better terms, to see what is the most important thing to you, and kind of start off your conversations with that.
That's great. Thank you. Thank you so much. And bringing forward those key points. Kim, if you want to sort of go to the slide on the training, that's great. Thank you. Just want to sort of highlight for folks. So you heard mention, sorry, Vicky got bounced out for whatever reason in terms of the session, but she talked a bit about Voice of the Child report training. You'll see some dates there in terms of, this is a very interactive. You learn skills and certain practices, role play components that tied into it. And it's sometimes incorporated and contracted to be part of the child protection mediation process to bring it forward. In some regards, what you just heard the past Uma, when she was speaking, share some information. She's really highlighting, bringing forward voices of particular children. The child inclusive mediation training, there's a session coming up in April. Again, it's a very skill-based interactive process. There's also a BC model out there from British Columbia, where I currently sit at the moment, hearing the child aspect. And again, older children may want to be more directly involved in the process. And so facilitating a child inclusive mediation as a component. There are other trainings, other considerations to keep in mind. You may have heard of the work of Lori Yasnik in Alberta. She runs a multi-day intensive. It's more of a play and meeting-based model. Some of it is designed for younger aged children in terms of helping to facilitate the in play activities, bringing forward some of the items that are important from the child's point of view. I've referenced a particular article there from FCR's The Family Court Review, which is put out by the Association for Family and Conciliation Courts. Volume 54, number 2, page 186 to 202, you'll see an article by Yasnik and Jean Graham entitled The Continuum of Including Children in the ADR Processes, a Child-Centered Continuum Model. A wonderful article if you haven't had a chance to take a look at it, just to think about some of these things from a child's point of view. And I know that, I'm sorry we got started a bit late, but our contact information is there for reaching out to any of us about some of these aspects. And again, perhaps if we take the slides down, we can sort of pull people up and see if there's sort of any last minute questions.
Thank you very much, Kim and Dan, and Vicky, who was unable to find her way back into the session, unfortunately. But if anyone does have any questions, please do put them in the chat or feel free to talk. And if we don't get to your question, please just, again, put it in the chat and I will make sure to get that question answered for you at a later time.
Certainly, thank you. And thank you folks for bearing with us in terms of the technical hiccups at the beginning. And I know you've had a very full and wonderful day in terms of a variety of materials, and thank the organizers for facilitating this particular day for all of us.
I think Paula, did you have a question, Paula? I saw your
More
hand.
of a comment in response to, I'm sorry, I can't really see people. I'm sure it's a user problem. But the person who was talking about the signs of safety and some of the work that comes out of that, I did a child protection mediation and it was powerful. It was incredibly powerful. Is it disclosing? Am I able to say? It's non-identifying, I guess so, right? Can I talk about the picture?
If you don't use any names.
Right, yeah.
Yeah.
So anyway, so there had been abuse by the father, and this boy did a picture of himself outside of dad's house with his siblings, and it was lightning outside. It was dark and it was lightning, and it was all about how he would feel safer outside the house in the lightning than he would inside of the house. But it was so powerful. I had never been exposed to something like that.
Yeah, and thank you for sharing that, Paula. Just in terms of you know, the children's artwork can be incredibly enlightening. And that's some of what the different training courses will also sort of highlight in terms of that. And welcome back, Vicky. Sorry you got bumped.
I think that's our experience as well, Paula. When you hear the children's voices, we often put it in the first person. So you're relaying the information to the parents in the first person in the child's exact voice, the way they would say it.
Right.
And it just is so palpable, the impact to the parents in terms of how they think about things and just how they adjust their behavior when they hear it, and how they're often willing to think a little bit more broadly about their children and their children's needs.
Mm.
So there's no, I think that's why it's such a powerful tool of settlement. There's just nothing else more compelling than hearing your children share their views, right?
Yeah.
My apologies to the group. I got booted out and then it actually shut my computer right off and I couldn't turn it back on. So
Oh
my
my.
apologies. Yeah.
One of the other pieces that I once did was the kids were severely traumatized. I actually there was a very good therapist working with kids that had reactive attachment disorders, and actually had the therapist come in because the depth in which to go in and explain that it was involved. So I did do that once as well, which actually had her there, which was very powerful and necessary.
Yeah. Thank you.
To do an education piece.
Yeah, for
And
sure.
just, attaching to that education piece, I think one of the wonderful aspects of the child protection mediation and various mediation initiatives is the value that families will take away, various resources, various educational information that perhaps highlights, resources in their community or things that perhaps they weren't aware of, that they now have a better understanding in terms of what their children have gone through in those particular aspects. And so very, very key role in terms of the educational aspect that unfolds in the mediation process too. Okay, I think we're
at our time.
at our
Yeah,
time,
so-
and folks need to go back to other rooms. But thank you so much for joining us, everybody. And again,
Yes.
our apologies for the technical hiccups.
And on behalf of the provincial ADR,
Afternoon.
All right. Take care,
Amen.
Kim, Vicky. Thanks again, both
You
of
too.
you.
Okay.
Yeah, Kim and Dan, sorry. Thank
Oh.
you. For
It's
stepping
all
in.
good.
Oh.
It's all good.
I had to call my son.
Yeah, life these days, eh? Yeah.
Thank you.
Bye,
Bye-bye.
everyone.